just like in a regular syndication, when you're doing a fund of funds, you've got to register, find an exemption, or it's illegal, right? So you're going to see the same discussions about, are we doing a 506B? Are we doing a 506C? Are we doing a Reg A? Are we doing regulated crowdfunding? Whatever mechanism you're looking for to raise the capital into the fund of funds is going to be exactly the same. So that compliance part remains the same. Because you're in the business of investing in stock or securities as opposed to real estate directly, you are considered by the SEC as an investment advisor. Welcome back to episode 35 of Real Estate Syndicator Live. Super excited today to talk about fund of funds. We're going to do a deep dive into fund of funds. We briefly talked about it, I think, in episode 2 when we talked about funds in general. But today I wanted to do a deep dive primarily because people have been asking about, really asking about the compensation limitations. Because we do see as one of the big mistakes that we see when people put together fund of funds. The way the manager or the person putting together the funds is getting compensated. So we're going to do a little deep dive into fund of funds and obviously open it up to questions. Let's start with sort of the things you need to be aware. Well, actually, we're not going to start. I'll take that back. We're not going to start with things you need to be aware of. I'm actually going to start with a couple of schematics, because a lot of people have kind of told me that they have a hard time getting their mind around what exactly a fund of funds is, even though I think, because we do it all the time, in my mind, it's relatively simple. And I think maybe folks think it's overcomplicates things, but I'm going to share my screen. I don't usually do this, as you guys know, but I'm going to do it today because I don't know, I think it's easier when you're seeing it. So hopefully you guys can see my screen, but this is just a simple, this one is sort of the syndication, right? So typically you have the green is your syndication LLC, just everyday deal. You buy a piece of property and then you have investors come in, right? Class A are your investors, Class B is typically the sponsor, and then you have some kind of a GP entity, a management company that does. That's your typical syndication that everybody should be aware of if they've done one. All we're doing when we're doing fund of funds is, instead of investing in real estate like in a typical syndication, you're going to go ahead and invest in other people's syndications. And ideally, you're doing it in multiple different syndications. So ideally, we're doing this as what we call a blind fund, meaning you're actually raising money into your syndication. But again, instead of buying property, you're going to go out there and look for other syndications, other people that are raising money to go buy property, or honestly to buy whatever. I guess it doesn't have to be real estate, but we're assuming it's real estate. But you're going to raise money into your fund. You're going to have same thing, Class A, Class B. Let's assume maybe it's an 80-20 split. You got your GP. Everything's the same up here. But instead of buying a piece of property, you're going to buy some percentage, some LP interest in somebody else's syndication. And so that's why I put these little other LPs here, because you're not going to own 100% of this. You're going to own maybe 5, 10, 15% of it. And then there's going to be other LPs. Now, what we're going to talk about in a second here is that you are probably going to get some preferential treatment, but this is kind of the basic structure. And it is important, like I mentioned before, not to do one where you're just investing in one property. And by the way, if you're watching this on the video, I'm going to put a link to the bottom so you can actually follow with the schematic. But anyway, that's what a fund of funds is. It's exactly the same on the top as if you were doing a regular syndication, but instead of buying a piece of property, you are buying literally shares in somebody else's company. In this case, they're LLCs, so they're actually membership units, but you're basically buying shares in a company, just like you're buying shares in Apple or Microsoft. And that's a really important distinction, because as you guys know, when you're doing a syndication and buying real estate, you don't need any type of license to do that. I mean, you don't even need a real estate license. You can go buy real estate and don't ask anybody for permission. But when you're in the business of actually buying real estate, when you're buying securities, meaning you're buying LP interests in another company, now you're in the business of buying securities. And that's kind of what opens up a whole new area of compliance. And so that's what we're going to talk about today. Now, remember, if you guys have seen some of my content, I always talk about there's two things that syndicators do, right? One is raise the capital into your LLC, and then the other one is deploy it. And so again, in a typical syndication, you're deploying it to buy real estate. In this fund to fund structure, you're raising capital, and instead of buying real estate, you're going to go buy shares in somebody else's company. And so that's what really opens this thing up to the regulatory nightmare, I'm going to say, to be honest with you. So in addition to thinking about the typical things you have to worry about, so just like in a regular syndication, when you're doing a fund of funds, you've got to register, find an exemption, or it's illegal, right? So you're going to see the same discussions about, are we doing a 506B? Are we doing a 506C? Are we doing a Reg A? Are we doing regulated crowdfunding? Whatever mechanism you're looking for to raise the capital into the fund of funds is going to be exactly the same. So that compliance part remains the same. The additional compliance is really three other compliance pieces that you need to worry about. Number one is, because you're in the business of investing in stock or securities as opposed to real estate directly, you are considered by the SEC as an investment advisor. Because the way the SEC looks at it is that you're actually advising your syndication LLC, your fund, as to the purchase of securities. Right? I know we don't think of it that way, but that's really what you're doing as the manager, right? As the manager of the syndication, as a fund manager, you're advising your LLC what to go buy, right? And because on a regular syndication, you're advising your fund or your LLC to go buy real estate, we don't need any licenses. But when you are in the business of advising your fund to the purchase of securities, that makes you an investment advisor. Now, that per se isn't the end of the world. That just facilitates the next question, which is, well, great, what does that mean? Do I need to register as a registered investment advisor, or is there some sort of an exemption to registration? But whether you need to register as an investment advisor is sort of your next area of compliance that you need to think about. And not luckily, but it really is a state-by-state issue. So you're not even eligible to register at the federal with the SEC unless you've got $100 million in assets under management. So unless you're doing $100 million or in aggregate, you've been raising $100 million to do a fund of funds, then you're not even considered, you're not even eligible for SEC. So if you're an experienced syndicator out there that's been doing this for a while and you're approaching $100 million under management, I would highly recommend you connect with your SEC attorney, and don't wait till you get to 100. Once you get to about 80 or 85, why don't you start making some phone calls to figure out what you may need to be doing here shortly. But let's assume this is the first time you're doing a fund of funds, or you've been raising a few million or 10, 20, 30, 50 million, then it's going to be a state-by-state issue. And by state-by-state issue, I'm saying, where are you physically located where you're advising your fund? That for most of us is going to be in the state where we reside. So for example, if I was doing this, or even Bethany was doing this, we both reside in the great state of California. And so we would have to go to the state of California and figure out, hey, is there an exemption to me having to go and register as a registered investment advisor in California? And luckily, I think almost every single state, I think I've come across one or two that don't have exemptions, but pretty much every single state out there has an exemption. So you don't have to register as an investment advisor. And again, we just have to look at your particular state. Some states are very liberal, like Pennsylvania. They don't really care. Actually, we were looking at, I think, North Carolina this morning, Bethany. North Carolina is similar in that way as well, where they don't care as long as you're not doing more than like 15, some are 5, some are 15, but as long as you're not doing a bunch of these fund of funds, because each fund is just one, so you're advising one fund. So as long as you're not doing like more than 5 or 15, and you're not holding yourself out to be as an investment advisor, which most of us aren't, then you're exempt from registration. Those are kind of the easy states, like I mentioned, Philadelphia and North Carolina, and there's a bunch of those. Then there's other states that are kind of in the middle of the compliance range. Like I always bring up Texas as an example, because Texas, there's a nice exemption, but they say you don't have to register, but you're going to be limited to only accredited investors in your fund. Right. So even if you're doing a 506B fund, you can do a 506B, but every investor would have to be an accredited investor in the state of Texas. And there's some forms, we call it a truncated ADV form, that we have to file with the state of Texas. Relatively easy. You can probably do it yourself, although most people hire somebody to do it. And then there's the really tough states where if you live in one of these states like Massachusetts or Washington or some of these really restrictive states, it basically makes it impractical for you to do one of these, because in Massachusetts, for example, there's an exemption, but you have to limit your investors to basically accredited investors that have $2 million in net worth, not one. And in some states like Washington, we've got some clients that we're wanting to do in Washington, they have to be qualified clients, or I'm sorry, qualified purchasers, which I believe are $5 million in assets that they have, investable assets. So again, that really kind of eliminates all of us. And in those states, again, it doesn't mean you can't do it. It just means you're going to have to go through the registration process and register as an investment advisor, which again, it's not the end of the world, by the way. If this is something that you really want to do and you're good at it and you plan to do it more than one, then look into registering with your state. I mean, getting the registration itself is, I don't want to say easy, but it's not super complicated. You take an exam and fill out an application, pay an application fee. The pain is mostly the compliance, right? Audited financials, all these quarterly reports and all this stuff. And you just have the finger of regulation over you, but it's not the end of the world. So just because you live in a state like Washington, you just need to consider that maybe if this is something you want to do for a living or you're good at it, maybe you go register. So anyway, so that's sort of the first or the second, I guess. So the first would be that 506B, you've got to find the exemption just like anything else. The second one would be, do you need to register as an investment advisor? The third one is when you're just a holding company, when you're just literally sitting there and owning LP interest in other deals, you're just a holding company, and that subjects you to the Investment Companies Act of 1940, which is a whole other body of regulation, which, trust me, you don't want to be considered an investment company. And so you need to find an exemption to that. And the most common one is what we call a 3C1 exemption, which means if you've got less than 100 investors in your fund, then you become a 3C1 investor and you'd be exempt from having to register as under the Investment Companies Act. So that's whenever you've heard that term of, hey, 100 investor limitation, that's when it comes from. And actually, technically it's 99 because you've got to consider, the GP is one of them. And another word of caution, whether you have one investor or more than one investor gets complicated too. So don't just assume that it's 100. For example, a simple one is if you have an entity as an LP and that entity ends up having 4 or 5, investors in it, that may count 5 against your limitation. So you always want to have your securities counsel, consult with your securities counsel regarding whether, you really do have 100. So if you get anywhere close to that, and again, most of us are doing funds that have 20, 30, 40 investors, but if you're going to get close to that, the funded funds. So the Investment Companies Act is the third one, and then the last one that I really wanted to focus on a little bit more today is you still have to worry about not being a broker dealer. You remember, the reason people are doing this a lot of times is they want to avoid this issue of becoming a broker dealer. You don't want to register as a broker dealer, but if you're raising capital for somebody else, and in this case, it's very easy to see that it could be seen as you basically creating a fund and raising money for some other operator. So we want to make sure we don't appear to be, and we actually do not act as a broker dealer, because if all we're doing is raising money for a particular deal, turning around, collecting the money and turning it over to that other operator and investing, into the LP, then you're really just raising money for them. I mean, you just have a smoke and mirrors, as I like to call it, all these entity structures in a fund and invest in a different fund. But at the end of the day, again, SEC usually likes to look straight through all these issues. At the end of the day, you're just raising money for somebody else. So you've got to make sure you're structuring your fund in such a way that you're not just raising capital for the operator, or at least perceived of that. You don't want to be receiving what we call a disguised commission, right? Because you're just disguising it through all these entities. And so how do you make that happen? How do you ensure that what you're getting compensated for is not just raising money for this operator, but for other stuff? And there's probably 4 or 5 categories of things that you want to think through. The first thing is you want to be able to show and actually do the due diligence, right? So one of the things your investors are paying you to do, because they're busy professionals, they don't have time to do, is go do the due diligence, not only on the sponsor, but also on the individual property. So in an ideal world, you've already sort of, you go enter into these relationships with these operators, you go down and meet them, you fly down, so you've got plane tickets to show, and you've got a way to prove that you went down there. But you're not only are you vetting the individuals, but you're looking at their operations and you're doing your due diligence on their people, processes, and systems, right? So again, that's something that adds a tremendous amount of value to a passive investor like myself, where I don't have time to hop on a plane to Atlanta to go meet with these guys for 2 days and make sure that you vet the sponsor. So that's a big value add. And then ideally, if they've got a deal where it's a piece of property, ideally you're going down there and doing sort of a walkthrough and you're doing a due diligence on the property. Again, that's something that you're adding value to your investors. So due diligence is kind of the first thing that you want to be doing or being able to prove when you're doing one of these funded funds. The other thing you should absolutely be doing is you should be negotiating better deals for your fund and your investors, right? If you have a fund and, let's say an operator has a syndication and their minimum investment is $100,000, right, to come into their deal, and you show up with $1 million or $5 million, you should be negotiating better terms, and the sponsor will be happy to give you special terms because, number one, you're coming in with a big chunk of money, and number two, you're making their life a lot easier. Like, they don't have to talk to 30 investors. They've got one fund manager that they can communicate with, one K1 they've got to issue. It's a lot less administrative work when you have that stuff. So, and plus it's a lot of money, right? So if you're coming with 20% of the raise or 40% of the raise or 50% of the raise, it's not unreasonable for you to ask for better terms. So if the investors are getting, I don't know, like an 8% pref, there's nothing wrong with you negotiating a 10% pref. Or if the splits are, 70-30, there's nothing wrong with you negotiating, a 75-25. That generates additional revenue for your fund, right? Because think about it, your revenue is basically just the distributions that sub-syndicator is going to be making. So at the end of every quarter, collect all the rents. When the LPs get their 80% cash flow or 75% cash flow, your percentage of that cash flow is basically your revenues, right? And so if you can negotiate better terms, that actually increases the revenue that your fund receives, which then allows you to go in there and take your fees, 2% asset management fee, acquisition fees, the carried interest or whatever. That's how you really get compensated. One of the things you want to really be careful with, what you do not want to be doing is taking direct compensation as the fund manager from the underlying syndications. So if I'm investing, let's say Bethany has a syndication, I'm doing my fund of funds and I'm going to give Bethany $1 million. I can't have Bethany write me a check because I invested $1 million into the deal. That's not how I can get compensated. That would be basically, I don't even know if it's called a disguised commission. That would just be sort of an illegal commission that you're receiving. Because again, you cannot get compensated to raise capital. That's not what you're getting compensated for. You're getting compensated for putting together the syndication, going through the process, doing your PPM, and then adding value to investors. Again, due diligence, negotiate better terms, providing access, right? A lot of these great investments, I was just looking at an investment the other day, it was an amazing investment, but the minimum investment is $500,000. Maybe you don't have 500 grand, or maybe you don't want to spend $500,000 on one investment. So one of the services that these funds do is they have lower minimums. So if the minimum's 500 for the main one, and your investors can get in for 100 grand, or maybe it's $100,000 minimum, but your minimum is 25 or 50. But at the end of the day, you are providing access to investors who maybe otherwise couldn't access the investment because the minimum is so high. And then honestly, awareness is another value add that I think sometimes is overlooked from a sponsor. I mean, a lot of times these past investors wouldn't even know some of these investments exist if it wasn't for you. So that's obviously adding value. But the whole point of this is that you're doing things to add value to investors, and that's what you're getting compensated for. You are not getting compensated for simply raising money and turning it around to invest in an individual things. And that's why we strongly believe that it's very difficult, I'm not saying it's impossible, but very, very difficult to do a fund of funds where you first identify one particular operator and you hear, hey, this operator is looking for $5 million, and you go to that operator and say, hey, I'll go raise $1 million for you. And then you go create your fund, raise $1 million and give it to the operator. To me, that looks like you're acting as a broker-dealer. So the way that Bethany and I prefer to do these, and we're pretty strict on them, is that you do what we call a blind fund, which is you're raising the money without actually talking necessarily, or maybe you haven't even identified the underlying syndications, but you're raising $5 million to go, invest in, other operators that are in the multifamily space on this size, and, whatever the parameters that we do in a fund. That way, you're also getting compensated for basically picking the asset, right? You're trying to, you're basically being I don't say a stock picker, but that's one of the things you're getting paid for. So clearly you've got to be doing your due diligence. But when you pre-identify the asset and your intent is simply to go raise money for that particular deal, it becomes really hard for you to show that what you're basically doing is raising capital for that specific investor. But in terms of the compensation, I think the biggest mistake that Bethany and I see is just circumventing your fund to get compensated. Your compensation must come from the fund, period and full stop. You cannot be a fund manager and say, hey, I'm gonna invest $1 million in your fund, but then you give me some GP interest over here, or you pay me some additional money, right? The same rules have to apply. You must be doing, no transaction-based compensation. You must be doing substantial duties. All those same rules apply for co-sponsors with the fund. And so if you're simply getting compensated and given 5% of the GP because you invested $2 million into this person's fund, that's going to be a transaction-based compensation and prohibited under the broker-dealer laws. So just make sure that you get compensated from your fund. And the way you get compensated by your fund is to obtain more revenue into your fund by negotiating better terms. And hopefully that is something that also benefits the investors, meaning you've generated not enough additional revenue into your funds that not only you're able to pull your fees from, but it also potentially increases your investors' return. Like if they invested directly with the operator, they would have gotten a 12% return, but because you negotiate better terms, they're getting a 12.5 or 13% return. So anyway, that's kind of my my babble for today. I know it's yeah, there's a lot of you on the line. I didn't realize that. Well, it sounds like it's a cool thing. So anyway, so that's kind of my thing. I know there's a lot of questions here, and I'm not gonna. Bethany's really struggling with her voice today, so I'm not gonna have her. But I do have a couple of other questions that I was gonna go through before I get to your guys' question. Oh, there's a lot of questions here, so I also want to make sure I get to you guys. But you know, one of the questions, for example, was are we able to legally structure a waterfall hurdle within the fund? For example, you know, 80-20 split, and then anything above a 15% or 18% IRR. The answer is yes. It's no different than a typical syndication, except for the fact that you're not investing directly into the asset. You're investing, you know, into shares of another company. But you can do, once it gets to your fund, your revenue, you can do whatever you want. What I like to see, by the way, and this is another issue I've seen sometimes, is you don't want to negotiate. Let's say you negotiated $50,000 more revenue into your fund. You don't want to then you don't want to take a fee of $50,000, because that's just going to be, again, looking like a disguised commission that's just kind of making its way up the structure. Make sure your structure is sort of traditional, right? 80-20, 2%, 2 and 20, whatever you want to do, but you don't want to have it match exactly what the increased revenue is that you're receiving as a result of your negotiation. So negotiate better terms, get more revenue into your fund, and then take your traditional splits. Another question was, can we do a 506B fund? 100%. Again, that's part one. You've got to figure out whether you're going to do a Reg D, Reg A, anything like that. Can a fund own the assets it invests in? How do I do this? All right. I don't know why I can't see the end of this thing now. Apologize here for a second. I think the question was, can a fund own the assets it invests in at the end prior to exit? I think, like with any syndication, if your fund can negotiate, you want to, instead of selling it, I guess, to the market and to a third party, if you want to negotiate to sell it to your, you know, to your fund, you can certainly do that, again, as long as you're disclosing everything. The name of the game here is disclose, disclose, disclose. If you've disclosed to your investors that at the end of this, you know, full cycle, you have the option to, you know, sell this deal to your fund, or vice versa, you want to, it's in the fund and you want to sell it to yourself individually, or whatever you guys want to do, that's fine, so long as that is disclosed on the front end. For some reason, I'm having a little bit of an issue reading these, which is really a bummer, because I really wanted to get to these. Let me look at some of the questions here in the chat. So, and I should probably say again, if you guys are listening to this on YouTube, hit that like button for me. It'd be really helpful. And if you haven't subscribed, give me a subscribe. Really appreciate you guys who do that. Let's see here. The link to the bubbles. Oh, the link to the bubbles talk. You want to put that, if you haven't, Bethany's going to put that link. If it's already in there. Okay, good. Link to it. Is California one of the tougher states? You know, interesting, Lisa, great question. Is California one of the toughest states? Interesting enough, it's not. It's not one of the simplest states, but it kind of is in the middle of the road. You know, yes, I think they limit you to accredited investors only as well. It's very similar to Texas, but it's certainly not prohibitive to the extent of, you know, Massachusetts or Washington. So yes, it's a little bit more than usual, but we've had several clients who are in California who've done fund of funds and fit within that exemption. Alan Foster, where are the recordings? They're on the YouTube channel. I put them all up, usually pretty quick. We put them up on the Facebook community first, but because they're so long, I've got to put a link in there. So the links to the YouTube video. But if you guys aren't in the Facebook community, I would highly recommend you guys check it out. We're almost at 2,000 people. It's just mauriciorauld.com/FB group if you're interested there. And that's where I post a lot of the clips too, because I know it's an hour long or whatever. So we usually cut those up and post them there. What are the registration, Chad? What are the registration requirements if the fund of funds consists of only international investors? Ooh, check that out. If they consist of only international investors and they all live outside of the United States, and you do not market to the US and you do not sell in the US, then there's a special exemption for you. And that's a Reg S. We talk about Reg D, we talk about Reg A. This is Reg S as in Sam. And that quote unquote regulates international investors, but just think about it. The SEC not only doesn't care about international investors, their jurisdiction doesn't extend to international investors. And so if you're purely dealing with international investors, you're not going to have to worry about any of this other stuff. I would just do a Reg S exemption, and I've got videos on it. I think we did a live on international investors early on, but just make sure you're complying with the securities laws of whatever country your international investors are. There's some tax issues that you want to be aware of, the 30% withholding, but we did a live on that before, but I wouldn't be too concerned if all of your investors are international. Drew the troublemaker Pitchford is in the house. This may not be a question related to compliance. Is there a time limit to deploy the funds? Great question, actually. Is there a time limit to deploy the funds? Like if I raise a bunch now, but feel like the deals aren't where they need to be, can I just hold the funds as long as I want? Is that just an investor relations issue or a compliance issue? Let's talk about that, because that's a great question. Again, you've got to disclose whatever you're doing, right? So typically what we will do is we don't want to have a bunch of cash in our bank accounts, earning, let's say you're giving your investors a 6%, 7% pref, and you've got $10 million in your bank account, that pref is probably accruing. Or even if you're not earning any money, that may not be something the investors are happy about. So we typically recommend sort of a cash flow, a cash call model where if you don't have a deal right away, you may just want to take maybe 10% of the investment. So let's say it's $100,000 minimum. Instead of taking all 100,000 at the same time, you just have them put 10% down, 10 grand. And then whenever you need the cash, you put the language in the documents that within 5 days of the cash flow, you've got to give us the remaining 90%. And if for whatever reason you don't, you're going to forfeit that 10%. Because otherwise, that's one of the issues, is if it sits in your bank account for 6 months and it's not earning a return, that may or may not be problematic. But you can put down whatever terms you want. I've had clients put in there that, the 10%, for example, we'll take 10% now. Whenever we need the cash, we'll do the cash call for the other 90. We've heard people that over raise and say, look, we're going to hold it for, let's say 6 months, and we're going to pay you 2% while we hold it, or we're going to pay you whatever percent while you hold it. And that's generally over raise, because obviously if you're just starting, there's no capital. But as long as you disclose it, Drew, you can honestly do it however you want. It just depends on what your investors are looking for. I did a poll, I think not too long, maybe 6 months ago or so, about what people's thoughts were on this. And a lot of people came back and said, look, it is what it is. I mean, let's just collect all the money. If it sits in there and doesn't earn a return, the whole thing is, what is the ultimate return from the entire project? Yeah, you may not be earning anything for the first 3 months or 6 months, but by the time this is all said and done, 5, 10 years, it's going to more than make up for whatever lost money you have. And to be honest with you, how much are you really getting these days? And a little bit more, but not as much as you would think, in terms of, if it's just sitting in your bank account or your brokerage account, your opportunity cost isn't huge if you're not deploying that capital. But that's a good question, Drew. Thanks. May we have a clickable link to the Facebook group? I think Bethany, thank you, Bethany, for doing that. Bethany can't speak, but she can type. Thank you. Is there I think it says, is there a site that lists what states are easier to do a fund of funds? You know what, there is. So I'm going to do a plug here. Let me see what the name of it is. I'm going to do a plug for Alex. Alex Davies is more of a fund attorney. So we consult with him. We actually, sometimes, if you're a client of ours, you probably heard the name, we actually, retain him as well. He's got a great guide where it's kind of a cheat sheet that he does on his website. His website is strictlybusinesslawblog.com, strictlybusinesslawblog.com. And a lot of us attorneys who don't necessarily specialize in sort of, funds and investment company act, which we don't, obviously Bethany and I we really focus on Reg D and Reg A, but a lot of us rely on this great blog, Strictly Business Law Blog, Alex Davies. I should probably have him on one of these days, but he's got a great little, if you go up to the guides on the top right, you'll see that he's got basically a cheat sheet of all 50 states. Now, to be fair, or to be, like we've talked about this, he hasn't updated it in a while. So a lot of these are from 2016, 2017. So I always use these as kind of a first cut, kind of a general thing, but you obviously want to then dive into the actual statute or have your attorney review the actual statute to make sure it hasn't been updated or there isn't anything that's changed. So for example, one of the states, I think it was South Carolina, because we thought it was North Carolina, but it's not. One of the states, when I looked at this, said there's no exemption, so you have to register. But then when I looked into it, there was actually a relatively new law that had passed in 2019 or 2020 that did give us an exemption. So, but that's where I would start, strictlybusinesslawblog.com. And on the top right, you'll see a section called guides. So there you go, Alan. Oh, Alan, it's 2 a.m. here. Wow. Thank you for, I appreciate your webinar so much. I set an alarm. Thanks so much, Alan. That really, wow, that really is awesome. Appreciate that, buddy. Let's see here. Ronnie asks, is your fund limited to accredited investors only? No, well, here's an interesting thing. It depends, right? So obviously, if you're doing a 506C on your fund, you're going to be limited to accredited only. But also, you've got to be aware of what exemption the underlying fund is doing, right? Because if the underlying syndication is a 506C, for example, that means you have to be accredited. Your fund has to be accredited, which means all your investors need to be accredited. So it doesn't mean you have to do a 506C. Remember, you can do a 506B and have accrediteds only. But yeah, you got to be careful with what the underlying fund is. If you have non-accredited investors in your fund, you're going to be limited to only 506B deals. Basically, you wouldn't be allowed to invest in any of the of any 506C deals underlying. So that's one important consideration. And again, and also depending on the state, like again, if you're in Texas or California, in order to get that exemption, they're going to all have to be accredited investors. Let's see over here. Aman, can a fund raise from non-accredited investors and invest in a 506C fund? We just talked about that. You know what? I'll be honest about one thing that we're looking into, because I don't have an answer to that. And hopefully as soon as we get this answer, the rule on accredited investors is that in order for the LLC to be accredited, either all of the members of the LLC need to be accredited. That's the typical way. Or if the LLC has more than $5 million in assets that were not specifically obtained by the raise, right? So if you raise, if you're trying to invest in a 506C deal and you raise $5 million into your deal and put it in there, you're definitely not going to be eligible. But if you're doing one of these blind funds, right? Let's say you're going to raise $20 million into your blind fund, and then you invest something into a 506C, there's an argument to be made that the fund didn't really raise that money for the particular purpose of investing in your deal, because it was really raised for a blind fund in general. It's kind of, you know, it's on that line and very gray. I don't know which way it's going to fall, but that's the only potential argument I see. But we're looking for some case law to see if there's anything that the SEC has actually come out with on that. But generally speaking, for now, let's just assume that all of your investors have to be accredited, and so they would only be eligible to invest in 506C funds, or would not be eligible to 506C funds, or would not be eligible for any fund that required that accredited investors only invest. Which, by the way, a lot of 506Bs only allow accredited investors as well. So you got to be aware of that. Let's see here. Jeff, how do you avoid a double carried interest charge to your LPs? First one from the syndication and the second one from the returns to the fund. Yeah, I mean, you don't, in the sense that that's why you have to basically get additional revenue into your fund in order to be able to justify your fees. Because if you don't raise additional funds, then the argument can be made, well, the investors are better off not investing in your deal and investing directly with that sponsor. Now, again, we had a client call this morning where that wasn't even an option. Like, you're not even eligible to invest in, you know, that underlying deal. This is the particular case we were talking about. So that they weren't even eligible. So you don't even have a chance. So you have no way of getting those returns. But yeah, there's going to be a double. I mean, you're an LP, so you're only going to get 80%, you know, your share of the 80%, and then you're going to also take whatever carried interest you're taking. So there's really no way to avoid the double carried interest charge. I thought where you were going, Jeff, which is another issue, is, you know, you're not prohibited, as long as you disclose it, from investing in one of your own syndications. That's where you got to be really careful, though, because now you're getting paid double, right? You're getting paid at the syndication level, and then you're also getting paid at your fund level. So that either needs to be disclosed, has to be disclosed. And then a lot of clients just, you know, they only take it at one place. But if it's a true blind fund and the sub-syndicators are third parties, then there's really no way to avoid that. That's just the nature of the beast. Hope that answered the question, Jeff. Sorry, I missed you here. Sarah, yes, it is. Hey, Sarah, how are you? Will the investors get a K1 statement? Great question. So what happens is that, again, you're a limited partner in somebody else's deal. So your fund will receive a 1K1, right, for whatever the total aggregate amount of distributions your fund received. And then you're going to do like any other syndication. You're going to go to your CPA. The CPA is going to file a tax return for your fund, and it's going to issue K1s to every single investor that you have. So you receive a K1 to document the revenue you received from all the underlying, when I say one K1 from each, each syndicator that you're investing in. And then you have to then turn around and file your tax returns for your fund and issue 10, 20, 30, 50 K1s to your investors. Sarah says qualified clients only in California. We have to double check that. I'm not sure if that's, I thought it was accredited, but we can double check that. We're actually going to do another follow-up blog. This is such a, although I didn't think that many people were going to show up. This is a very niche topic, but we had, over 80 people show up today. So we're going to do a follow-up blog on some of the sort of the nitty-gritty details. Amy's in the house. Hey, Amy, how are you? If you haven't seen the webinar that I did for Amy and Amy Sarah Sullivan, I highly recommend you checking out. Bethany, I was waiting for China. Can international investors invest in a fund of funds? Yeah, just like any other deal. When you have international investors, it just depends on if it's just a regular, if you're not concerned about any of the regulatory things, we typically just bring, if it's just one international investor, they typically come in under, 506B, 506C, like any other deal. But if there's a lot, then you may want to bring them in under Reg S, as we talked about earlier. And there's nothing wrong. In fact, I encourage doing concurrent raises, meaning not even concurrent. Your documents would be, you would claim not only the 506C or 506B exemption under Reg D, but also you'd be relying on Reg S, and we incorporate the Reg S exemption into our PPM docs. That way you can fall back on either one. You're basically telling the SEC, we're raising this money pursuant to Reg D and or Reg S. So you have that option, but 100% international investors can invest. Hey, Sheldon, oh, you got good. Sheldon was our winner of the tax-free wealth book from Tom Wheelwright, and he says, thank you. You are welcome. David, I formed a single member LLC that has invested in a few syndications, fund of funds. I would now like to sell interest in that LLC to investors. I formed a single member LLC. Oh, this is great. I formed a single member LLC. So your own LLC, you funded it yourself, and you invest in a bunch of different syndications. Great. So I guess technically you have a fund of funds, but it's just you. You haven't really raised any money. Got it. I would now like to sell interest in that LLC to investors. Love it. How should I proceed in general? Also, is New York a tough state to get an exemption? Thank you. So a couple of things to consider when you're selling an existing LLC. The first is most people forget that when you're raising under 506B, is only for 506B, you have to provide your non-accredited investors with audited financials. That's in the rule. It's in the rule. Now, for most of us, the LLC that we create is brand new, right? We create a brand new LLC. So there are no financials, let alone audited financials. But that's not the case when you have an existing company. So a lot of people want to do sort of a round B or round C, and they want to keep the LLC, or they want to acquire an existing company. Or in your case, David, you've already got an LLC that's just you, but you want to sell, I don't know, maybe 30% of it, almost like re-liquefy it. But if you have, to the extent you have non-accredited investors, you're going to be required to provide them with audited financials for the past couple of years. And if they're accredited, you probably still need to send them the financials. They don't need to be audited, but as part of your disclosures, you want to obviously be showing them, the past track record and all that stuff. But generally speaking, we encourage that actually, doing syndicating your own stuff is great because, you kind of know where all the skeletons are buried and everything like that. So nothing wrong with doing that. Just be aware that ideally you just keep it to accrediteds only. That way you don't have to deal with you have to deal with the audited financials. Is New York a tough state? I don't know. I don't know I'm guessing it is, to be honest with you. I don't know off the top of my head what the exemption is in New York, but if you go to strictly, what is it again? Strictly Business Law blog, you can check out the state of New York to see if how difficult it is. Sarah Sullivan says, can one of your funds have a little bit left over? Can it invest in another one of your funds if you are the GP? But yeah, so yes, forget about even left over. I mean, you can definitely raise money into your blind fund and disclose to your investors that sometimes you may want to, or you have the right to invest in one of your own deals. Now, obviously you have a huge conflict of interest. And so number one, you want to disclose that conflict of interest in your docs, but also you want to make sure that you remember you're a fiduciary, right? So you've got to be in the, you've got to be acting in the best interest of your investors. So that's probably tough sometimes to do, but you can absolutely do it. You just need to disclose it. And what's really tricky is you want to be very careful with disclosing compensation. To Jeff's point earlier, I think it was Jeff, you don't want to, if you're double dipping, that's fine. Again, you just want to be super clear that you're disclosing that, hey, I'm getting an acquisition fee down here and I'm getting an acquisition up here as well. So disclose. I did have a question in my notes here that I can't read because they're literally half. Somebody was asking about acquisition fees. Oh, here it is. Can you take the acquisition fee do you take the acquisition fee at the fund level or at the GP level? I don't know why these all got all screwed up here in terms of acquisition fees. Typically on a fund of funds, your acquisition fee is taken at the time that you acquire the underlying syndication, right? So typically on a regular syndication, usually you're closing your fund, you're closing your syndication, and you're acquiring the property at the same time. And so usually at close, you're taking your 2% acquisition fee or whatever. Here, you would want to wait until you actually we actually acquire the underlying deal. So you're not going to take all of your acquisition fees up front. You're going to be taking them as you acquire. And that's true for a fund of funds or a regular blind fund. I mean, we've got a lot of clients that are, buying mobile home parks, for example. And so every time they acquire a mobile home park, that's when you take that 2% acquisition fee, not at the point that you raise the capital. Because remember, that acquisition fee, not only, it's not based on how much money you're raising. In fact, you don't want to have it based on how much you're raising, because that's, again, you're getting compensated to raise money. That's not what you're doing. So you want to make sure you're getting that acquisition fee based on the, the acquisition cost of the underlying asset. In this case, your underlying asset is the LP interest. Let's keep going here. Tenny asks, what if you need to raise more than you originally estimated? Can you just change the PPM docs? We really encourage you to put, a realistic number. Like if you're thinking you're going to raise 10 million, then put, up to 25 million or up to 50. It really, whether it's a material change or not, we could have that discussion, but some people could definitely argue that, hey, I invested in this deal because I thought it was going to be a $10 million fund, and now you suddenly changed it to 50. So you would want to put that in the documents ahead of time. So, hey, this is a $25 million fund, but the manager reserves the right to raise up to 100 million, or theoretically, we reserve the right to raise as much money as we want. That's going to cost you more because there's a little bit more risk for everyone involved. So typically you're offering your PPM, your legal fees are going to be based on how much money you're raising. So you don't want to tell your securities attorney that you're raising $100 million when realistically you're going to raise 3, because you're going to be paying for a $100 million deal versus a $3 million deal. But again, I sound like a broken record, but it's all about disclosure. So as long as that's disclosed in your docs that you have the right to increase the limits from 10 to 25. But the conversely is you can go higher. So you can, like, if you're thinking you're going to raise 5, you can say, I'm going to raise 25. And if you get to 5, then you just close it out. You don't have to raise whatever you put in the docs. You can cut it short. So if you have a $10 million fund and after 3 million, you're like, hey, this is it. I'm going to close up the fund and we're not going to accept any more monies. You can do that. I don't know if that's Amy's typos. Thanks, Alan. Strictly business. No, actually, that's not right. Let me just put it in here. But Alex Davies, anyway, he's a good friend of the firms, and we a lot of times we outsource or bring him in. Not just outsource, we actually bring him in for consulting to, especially on these fund of funds, because again, we're not experts in investment advisory rules. We're not experts in Investment Companies Act, so we typically want to bring in an expert to do that. Let's see what we got here. Pete, which fund allows acquiring business and real estate? I mean, there's a real estate, there's things called real estate funds or real estate companies. If you're acquiring both businesses and real estate, I don't know if there's a specific term for that. Bethany, do you know? Yeah. I don't know if that's got a special term. I would be cautious, by the way. Again, it's just it's not a legal thing, but the risk of those two assets are completely different. Like risks in real estate and risks in let's say you're doing a marijuana business or whatever business you're acquiring. But I don't think it's not I don't know. I don't think there is.
Legally speaking, it's the same regulations. In the business world, people hardly ever call it syndications. But it means the same thing. It's all the same thing. So it would still be a fund, but to put both under the same umbrella, I can tell you from experience, investors don't love it.
Yeah, Jeff says that, yes, this is Pete, a fund that acquires businesses, a venture capital fund or a private equity fund. I would not mix funds, confusing the LPs. Yeah, but there's also private equity funds invested in real estate, right? So a lot of our clients have a capital that comes from private equity funds. So there is private equity funds, there's real estate funds. I mean, these are just vernaculars. Venture capital is a defined term. So being a venture capital firm actually does carry consequences. So, and same as a hedge fund has some legal stuff. So I would just call yourselves either a real estate fund or a private equity fund. Ronnie asks, is exemption for the states based on where you live or where the entity was formed? It's where you live. It's where you're advising your fund. So that's usually where you live. Let's keep it simple. It's where you live. The caveat is theoretically, if I did have a client do this once, if you live on a border, I think this guy lived in Delaware, or his office was in Delaware, but he lived across state lines and he literally commuted to work and crossed state lines every day. So where your office is could potentially be it as well. But for our purposes, I would just assume it's wherever you reside, because that's where you're on the phone. That's where you're conducting business and you're advising your fund, at least in the eyes of the SEC. Ronnie, can you invest with your EQRP into your own fund? Can you invest in EQRP into your own fund? I don't know why not. I don't know why not. I don't know why not. That's my answer. Is the typical carry fee 2% of the fund? Yeah, not about carry, but it's the management fee is typically 2%. And I think that just comes from the hedge fund world, right? The 2 and 20, where they take a 2% assets under fee for assets under management, and then they take 20% of the profits. So that is a typical fee. Look at Jeff all over the place here. Thanks, Jeff. Pete, carried interest fees can be anything, typically 20 to 30%. Are you thinking of 2% assets under management fee, which is different? Thank you, Jeff. Sarah, I would love accredited. Yeah, let's double check. We'll double check that. And like I said, by the way, if you guys haven't checked out the new website, we've updated our website, premierlawgroup.net, and we're going to be putting a lot of new blogs in there, in addition to all the content, the videos that we do on the YouTube channel. So we'll do one on this stuff. Johnny, thoughts on if the SEC looks at the exemptions for 3C1 with more scrutiny versus 3C5? That's an Alex question. That's getting really in the weeds. So I don't know the answer to that, to be honest with you. In general, actually, it's usually 3C7 funds that is the sort of the other potential, although that does involve qualified, so it doesn't usually apply to us. But I don't know the answer to that, Johnny. That's outside of my wheelhouse. That's an Alex Davies question for sure. She had Alex on we probably should have had Alex on this one. Amy, we had such a great time with you, Mauricio. Thanks, Amy. I did too. And I know Beth. Oh, that's right. Bethany's coming on next week. Amy, you should do a little promotion there. We're going to put the link to Bethany coming on and speaking with Amy and Sarah. That they do a weekly webinar, which is a lot of fun. With your fund investors get depreciation 100%, assuming it's real estate. Yeah, if the underlying, again, everything flows through. These are all not disregarded, but they all flow through. So you're going to get, as the fund, you're going to get a K1 that's going to capture all of the depreciation from the underlying deals, and then your K1 to the investors is going to capture whatever the depreciation is there. So 100%. Man, I'm behind. Sorry, Amy. Here's the link to our webinar with Mauricio a few weeks ago. Thanks, you, Amy. Mauricio's also appreciate you guys. Do we have to complete the blue sky filings for all investors? Yes. Again, nothing different at that top level. It's 506B, 506C. So if you're doing a Reg D, which most of us are, then you've got to do the blue sky filings within 15 days of your first sale to the SEC. And then each state, you need to do it within 15 days of the first sale in that particular state. And it's arguable when is that first sale. If you look at our documents, we're very particular, and we say that the sale actually happens when you countersign the subscription agreement. But that's really a fallback. I would count the date as soon as they've signed the docs and wired you money and the money's in your bank, I would use that date. And let's use the subscription date as sort of just a backup. But yeah, that's 15 days from that first thing. Jeff says that New York requires a Series 65 investment advice. So Jeff is saying there's no, and I'm not saying yes or no, that because I haven't looked at it, that there's no exemption then, Jeff, that there's no exemption in New York to the investment advisory. Because if there's no exemption, then yes, you have to register and you've got to get a Series 65 or 82 or whatever it is. Baruch, if I'm doing fund of funds and I do not qualify as an accredited investor, but start raising money for a fund for accredited investors only, do I become accredited because of my fund is investing in that fund? So I'm not sure, I think this is where you're going. So one of the definition, if you look at the definition of accredited investor, which is, I think, Rule 501, if you are the sponsor, meaning if you're the GP or the, officer, executive officer, or director, so basically if you're the manager of the manager, if you're manager of the GP, then you are an accredited investor by definition in your fund, right? So if you're the manager of the issuer, which would be your fund, then you're going to be an accredited investor for your fund. Now, the question becomes, are you an accredited investor for purpose of the other person's fund? And I'm going to say no, because the statute is very clear that it's the director, the executive officer, or the manager, or the GP of the issuer. And the issuer is the fund from the fund of funds, not the underlying thing. So it just depends on where you're trying to categorize. So if you're doing a 506C on your own, you would qualify. But if you're investing, I don't believe your LLC would be accredited if you as a sponsor is not accredited, because you're a member of that LLC like everybody else. Ronnie, can you be a co-GP on a deal you are bringing your fund to as LP? Yes. Okay. Oh, sorry. Can you be a co-GP? Yeah, you can be a co-GP. So interesting. Can you be a co-GP on a deal you are bringing your fund to as an LP? Yes. You just need to, number one, disclose that, because there's going to be, especially on the compensation side. And number two, you just want to be really careful that, yeah, co-GP shares is because you're co-GPing, that you're actively involved in that deal, and that you're doing substantial duties, that you're not getting those GP shares because you brought in the money. But if it's not uncommon that, like if Bethany and I had our own syndication and we went out and bought a building and that we sponsored, and then I have my own fund, right, separate, and I want to invest money into the fund that Bethany and I have, I can do that. I just need to disclose that. There's obviously conflicts and all that stuff. And there's, but especially on compensation, I would be really anal about the compensation. I would be laying that sucker out line by line as to here's all the ways you get compensated. And I would break it down on the ways I get compensated on the underlying as a co-GP and also at my fund level. Tenny Williams, to everyone, is there a difference in paperwork between the private equity fund and the real estate fund? It's just terminology. It's just terminology in our world. It's just terminology. What if you and your partners are from different states? Does regulations of both states apply? Yeah, assuming both your partners are advising. I was trying to think of a scenario where that wouldn't be the case. I mean, if there's two of you, there's probably an argument to be made that if there's two of you and one of you is a legitimate co-sponsor, but you're not the manager, because the minute you're the manager of part of the management group and you're the manager of the syndication or a manager of the manager, then you're advising your fund. So like that case, you'd have to look at both states. But if there's a scenario potentially where you are not the manager, but you're a sponsor, you're just doing other substantial duties, then if you're not advising your fund, then I would argue that, potentially you can argue that you wouldn't have to register in your particular, you wouldn't have to worry about the states where you are, but most of us are managers of that manager. So generally speaking, you're going to be looking at multiple states if there's multiple sponsors. Jeff, just on fire today. 3C5 exemption is 50% real estate debt, no limit on number of investors. 3C1 is accredited 99 investors. 3C7 is 1,900 investors, but all have the $5 million. I know that 3C1 is the 5 million. Karen, California law refers to investors as accredited. That's right. I do believe California limits you, or not, in order to qualify for the accredited. In order to qualify for the exemption in California, one of those requirements is an accredited investor. They have to be accredited. Family and friends are exempt, so no one needs to be accredited. I don't know about that one. However, make sure they have experience in buying and selling real estate. Not sure about, I mean, family and friends can basically be, you could probably argue that everybody in the world is either a family or a friend. So we'll do a breakdown. We'll do a breakdown, but yeah, Karen, that may or may not be true. I don't know. I haven't looked at it in a while. Pete, we do not work with Bridger. I know who he is, but we do not work with him. When you say, Alan says, when you say register, what does that mean? Do you have to file paperwork with the state saying that you are running a fund of fund? When I say register, I literally mean having to obtain an investment advisory license with your state. So, and again, I'm not exactly sure if it's a series 65 or an 82. I saw that Jeff said 65. It's one of those, but you basically have to pass an exam. Let's call it a series 65. You pass the series 65 exam, you register with your state, and you become a registered investment advisor. And again, I don't think the application piece and becoming one is that big a deal, but then you're subject to all the compliances of your state, and each state's going to have different compliances, but I guarantee you there's going to be financial compliance, whether they're audited financials, there's going to be reports that you got to do, there's background checks, all kinds of regulatory, nonsense, as I like to call it. All right. I really wish, I think I answered everybody. Actually, what I've started doing in the Facebook group is there is actually a chat feature. So every week we have a topic and I'm making the chat. So people ask questions in the chat. So I answered most of these in there, but I want to see if there's anything else here that I missed that maybe is a good question.
Hey, Mauricio, sorry,
Yeah,
this is
yeah,
Johnny
go ahead.
Nelson.
Yeah, go ahead.
I asked a strange question above the difference between the C1 and C7.
Yeah.
Sorry, I had to step away. Literally a smoke detector was going off in my house. Yeah, C1, sorry, C1 and C5. Somebody, my attorney was saying, hey, it's an automatic flag. You go 506C, 506C, and you go with the exemption of the C1. You're gonna get flagged by the SEC just because there's, it's a fund of funds and you have less control over it. So more on the side of going strictly as an LP with no control over the underlying entity. I just want to know if you had any thoughts to pick that apart or deconstruct that, or what's your own take on those things?
The way I answered it earlier was it's a little outside my wheelhouse. We don't deal with investment advisory rules. We don't deal with funded funds. Alex is usually the person that we bring in and consult with. So you're getting into a little bit more minutia. So I don't know if one's riskier from the SEC's perspective than the other. But the second part of your question was a new one, which is it riskier to have control underlying or no control underlying? That's a different question, right? Whether you're a co-GP in the underlying deal, is that what you were referring to? Or are you just strictly talking about whether 3C1 is riskier than a 3C5?
Yeah, it's how the SEC sees it, I suppose it is. And it's like, so obviously I'm setting up the fund right now. And it's like, okay, do you want to go strictly as an LP? And, or will you sometimes be active, inside the underlying asset?
I mean, if you're active in the underlying asset, then I don't necessarily view that as a fund of funds, right? At that point, I mean, if you're actively involved in the bottom, then it just, I think to me, it just reverts to it sort of a blind fund, because if you're controlling and have control in the underlying fund. But I don't want to get in the weeds on that. That's a question for Alex, I think, and maybe we'll have him, come on, because that definitely it gets really in the minutia for that. That's why we usually bring him in.
Thank you.
Ben, I did see I see you coughing over there. You on there? I saw like half of your video. So I think I don't know if I should, I was definitely following, I was kind of following you, but I think maybe you and I can discuss, or maybe I'll do a rebuttal video, not a rebuttal, but maybe I'll do a video. I'm going to start doing those too. I'm going to start just answering questions on video. So maybe I'll go through that and record a video and then post it on the Facebook group. Does that work? Because I was following, sure. I was following you on that stuff, although some of the stuff you had a little bit mixed up, I think, but
the technicalities are neither here nor there, and I think I'm beating a dead horse because you covered it already. Okay, and I'm sure I'm not going to change your mind. But it was you made this like amazing case for all the value you can add as a manager of an SPV. The due diligence on the sponsor, the company's operations, the deal, the underwriting, touring the property, touring the comps, getting a lower minimum for your investors, potentially a better waterfall, and then the thing that moves it over to being like quote unquote safe is investing in multiple deals. I mean, to me, all the value I added was already there for a single deal. Like by putting it in multiple deals, now I'm becoming more of an investment advisor as well, as opposed to just doing all the stuff that I know how to do in the due diligence.
Yeah, and again, I'm not saying it's impossible. I just, you would literally, in my book, you'd have to show me, because again, it's your burden to prove all this stuff. So you'd have to literally show me plane tickets that you flew down to wherever the sponsors are, and you know, here's my due diligence, here's all the docs I received, all that stuff. And then hey, they had a property, and so I flew down to New Mexico and I did my walkthrough with my team, and then I decided, hey, yes, this is an investment that I'm comfortable for my investors. I think it just makes it harder and harder to do. I'm not saying it's impossible. It just makes me a little bit. Look, a lot of this stuff is not. It's not. Most of this stuff actually is not, you know, edged in stone, right? I mean, even if you cross all your T's, dot your I, you're not guaranteed that the SEC is not going to say, hey, look, you're basically getting compensated to raise money for others. So I'm just trying to give you guys more and more ammunition to make sure that there's no possibility, or that there's less possibility that a regulator will come after you and say, look, you were a broker dealer, you were basically raising capital for this person. If you've got multiple deals, it's harder to make that if almost impossible, the argument that you were just raising capital for Mauricio when you didn't even talk about Mauricio's deal in the docs. And maybe that's something I didn't really point out, but when you're doing a blind fund, you're not talking about the underlying deals, even if they're around. You're just saying, hey, I'm raising $10 million to go find really good operators in these 3 states or 10 states that have multifamily, you know, between 100 and 200 units. Like, you kind of give it the parameters, but you're not even selling a particular deal, because that's you're selling your expertise that you're going to go out and actually do that work for them. So that's why I think it's you know, it's safer to go with a blind fund than identifying a particular. I just don't like the idea of having to raise money. Like, your business plan is essentially the same business plan as the underlying operator. To me, that's, I don't know. I don't feel comfortable with that. To me, your business plan should be no reference to any business. I'm raising this money to go buy, you know, multifamily or mobile home parks or whatever parameters you're giving to your fund, and then you go out and find it. So that's the difference. Anyway, that's just I just don't feel comfortable enough. But then again, there's a lot of other securities attorneys, and I think Alex is one of them, that doesn't feel comfortable taking clients that take non-accredited investors in their deal. They just don't feel comfortable. No matter how good your PPM is, no matter how good your disclosures is, they won't take clients that take non-accredited investors. They just think it's too risky. So, you know, there's something for everyone. All right, guys, I got to head back. It's a little bit past the hour, so I always appreciate you guys sticking around and coming to visit us, and looking forward to see you guys next Tuesday for episode 36. See you guys next week. Bye.